Good morning, everyone. Welcome back to our channel for continuation of our criminal law series. Those who are attending today for the first time, please ensure to go back to our channel and watch the previous discussions. In today's live session, we will delve into the intricacies of representing your client in a check bounce case. Check bounce cases, governed by specific legal provisions, require careful navigation to protect your client's interests and ensure a favorable outcome. In this session, we will provide you comprehensive guidance on the procedural aspects, legal defenses, and strategic approaches involved in defending a client facing a check bounce allegation. From understanding the legal framework to crafting effective defenses, we will equip you with the tools to advocate for your client with confidence. Whether you are a legal professional or an individual navigating the complexities of a check bounce litigation, this session will provide invaluable insights and practical strategies for success. Don't miss out on this opportunity to enhance your advocacy skills and effectively represent your client in check bounce cases. I welcome back our speaker for the session, Beeta Bajwa, an accomplished criminal lawyer with an impressive 14 years of experience specializing in the realm of criminal trials. Welcome and over to you, ma'am.
Thank you so much, Swatilekha. Good morning, everyone. So, our today's topic is going to be on how to represent your client in cases of dishonor of check, which basically means we are going to deal with the act called as the Negotiable Instruments Act 1881. Now, you may have heard it on day-to-day basis, which is a very common thing which you will hear again and again, that whenever a check is dishonored, you will hear people saying that I'm going to file a case of 138 against you. I'm going to file a case of dishonor against you. That's when the Negotiable Instrument Act comes into force. When do you take recourse into what are the instruments which are covered under the NI Act, and what is the procedure to proceed in a complaint under the NI Act? Now, when we come down to the NI Act, which we call as the Negotiable Instruments Act, there are three types of instruments which are covered under this Act. One is the most common being the checks. Your checks, when they are dishonored, are covered under the NI Act. Dishonors are covered under the NI Act. Then second, you have promissory notes, wherein promissory notes are executed between two parties, wherein one party promises the other party that he is going to repay back the amount in so and so time. Third, you have which we call as the bills of exchange. All these three instruments are covered under the NI Act. So whenever there is a dishonor or a non-compliance of any of these instruments, then the person can take recourse under the NI Act, that is the Negotiable Instruments Act. Now, when does the NI Act come into force and what is the procedure? As soon as a check is issued to a person, the person goes and deposits the check in the bank. Earlier, we used to have that the validity of check used to be 6 months. Now it is only 3 months. 3 months means, for example, say I have a check which is issued for today's date, which is the 21st of April, May, June, July. This check will be valid only till 21st of July. After 21st of July, if I'm going to deposit the check, then it is not going to be dishonored for any other reason. It's going to be dishonored for the reason that it is time barred. Whereas if I deposit the check within the time frame of 3 months and it gets dishonored, then can be various reasons for which it is dishonored. For example, the most common being the funds insufficient, wherein the person does not have sufficient funds in his bank account, and that is the reason the check is dishonored. Second would be payment stopped by drawer, wherein the other side who has issued the check to you would go and give an instruction to the bank that if this check comes for clearing, the payment may kindly be stopped. This is called as payment stopped by drawer. This is also an offense under the NI Act. So if your check gets dishonored for, say, funds insufficient or for payment stopped by fraud or for any other reason, it would be a offense under the NI Act. Now, what is the procedure when the check gets dishonored? As soon as the check gets dishonored, a bank issues a dishonor memo to the person who had deposited the check. That memo will give the reasons for the dishonor as to why the check was dishonored. Your limitation under the NI Act starts as soon as you receive the dishonor memo. So today it's the 21st of April. I deposit a check on 21st of April. It gets dishonored and I receive the bank memo on 22nd of April. So then my limitation to send a demand notice under section 138 subsection B to the other side starts from 22nd of April. Now it means that basically the limitation means that the cause of action has arisen and I have to send him a demand notice under section 138 subsection B, wherein you call upon the person who had issued the check that this check was issued by you under your legally enforceable debt slash liability, and therefore you may kindly repay me back the amount which is due as per the check within 15 days of the receipt of the notice. So as soon as you receive the bank dishonor memo, within 30 days, you have to send the demand notice. So if I have deposited the check on 21st of April and it gets dishonored on 22nd of April, as per the limitation, within 30 days, April is 30 days, so 22nd of April, from 22nd of April to 22nd of May, that is how you have to send the demand notice within 30 days. Now before we go further, let us just go through a draft as to what exactly should be incorporated in your demand notice and how is the demand notice to be executed. It goes on the letterhead of the advocate. I am concerned on behalf of my client, Mr. So and so, and address so and so. Then you have to give a facts. You will have to give facts like here. Now, this is basically a format wherein this was a friendly loan, okay, wherein one person had given a friendly loan of 2 lakh rupees to another person. In lieu, she had issued checks which were dishonored. So I have given the brief facts as to what was the relation between the complainant and the accused. Okay. Once this is done, then you will have to mention that how that amount was given. You will also notice that sometimes the amount is given to the accused, say in by through bank transfer. So you need to mention as to on which date, through which bank you had transferred the amount to which account of the accused. After that, you will say this, that you will give their brief facts that when how it was given, like here this amount was given in cash, so it is written as cash. Now here, once the cash was given, the accused had issued a check, a post dated check to the complainant, wherein it was clearly mentioned as to for what reasons the check was dishonored. Now, this person had apparently issued multiple checks. So, I have also mentioned about the earlier checks issue, that why it was dishonored. Therein, the earlier check, after it was dishonored, and you give a brief background as to what occurred where you had informed the accused. Now, here there was also a declaration dated 27th of November 2015, they are not stamp paper, wherein the accused had admitted that she will return back the money, and that is why we mentioned about the declaration. Now, here, if you come down to this paragraph, the paragraph after this is the main paragraph, you always have to remember that after the declaration, that towards your legally enforceable debt slash liability. These words are very, very, very important when we come down to a 138 proceedings. You issued a check bearing number so and so, dated so and so, drawn on which bank, which branch, or an amount of rupees so and so, bearing your signature. Our client deposited the check with his bankers so and so, which was dishonored for reasons funds insufficient and was duly intimated to a client on 27th so and so. Now, even after the dishonor, you have failed to repay back a client the said amount. and then we go down to that if he's cheated. And this is how your end paragraph goes as: under these circumstances, a client is instructed to call upon you to pay him a sum of rupees so and so. Always remember, when you call upon in the demand notice, you can only mention about the check amount. Say, for example, your due or your debt to the other person maybe say of 6 lakhs, and he gives you a check of 2 lakhs, and that 2 lakhs check is dishonored. The demand notice can be issued only for the 2 lakhs and not for 6. This is a common mistake which you will notice in a lot of demand 138 notices, that the dishonor of the check would be for a lesser amount and the demand notice would be for a higher amount. Do not do that, because if you do that, your demand notice becomes faulty. It is a technical lacuna due to which your 138 proceedings can get vitiated. Okay. Pay him a sum of rupees 2 lakhs covered by aforesaid check within 15 days of receipt of this demand notice, failing which proceedings under 138 of the NI Act would be filed against the appropriate court of law. Okay. Now this we basically write for 420 only to pressurize the other side. It is not mandatory that you have to write, but in the end you do make it a point that you write that this may be taken as a demand notice. Please go down under section 138 subsection B. The subsection B is missing over here. Okay, of the NI Act. Always remember, you do make a notice at the end, do write it that this is a demand notice. You will also notice that many a time in 138 notices, people don't write the bank check numbers properly. They don't write the dates. They don't write on which bank it was drawn. They don't write the details of the bank to which it was deposited, with branch. They don't use the words legally enforceable debt / liability. All these things are very, very, very important. Also, the transaction between the complainant and the accused is also to be mentioned. This is mandatory. It is necessary that you mention it in the 138 notice, because if you don't do that during the cross examination, because it will be taken as an addition, because it will come in your complaint, it will come in your chief examination, but it will not come in your demand notice. Now that happens once the check gets dishonored. You receive the bank dishonor memo, you issue the demand notice within 30 days. Now once the demand notice is issued to the accused and he receives the notice, within 15 days from the receipt of the notice, the accused has to repay back the amount covered under the check to the complainant. If the accused does not repay back the amount within 15 days, then your cause of action arises from the 16th day. For example, as I said, 21st of April, 22nd of April, the check gets dishonored. I have to send the demand notice by 22nd of May. Say I send the demand notice on 30th of April. The accused receives it on 1st of May. Okay. Now, from 1st of May, within 15 days, that is till 15th of May, the accused has to repay back me the money. If by 15th of May he doesn't repay back the money, then the cause of action to file a criminal complaint under section 138 arises from the 16th day, that is the 16th of May. And within 30 days, from the 16th day, within 30 days, the complainant has to go before the appropriate magistrate court and file a complaint under section 138 of the NI Act. So here the most easy calculation would be that once the notice is served to the accused, you have 45 days, and within 45 days you have to go and file the complaint. How 45 days? He receives the notice, 15 days which he is given the grace period for which he has to return back the money. If within the 15 days he does not return back the money, then the next 30 days, calculate the next 30 plus 30 days, you will have to go and file the complaint. Also remember, do not file your criminal complaint before the 15 days are complete, because your cause of action is only starts from the 16th day and it does not start from within those 15 days, the grace period. So if you file, so your complaint would be a premature complaint which can get quashed in revision also, or even by the High Court in a proceeding in a writ petition for quashing. So please be careful of these facts. Once the 15 days are over, your cause of action has arisen on 16th. On the 16th day, you go before the magistrate and you file a complaint under section 138 of the NI Act, and that complaint is also filed in the format of a criminal complaint, wherein it will be a replica of your demand notice. Only difference would be herein you will be annexing all the documents which are in your favor. So Atileka, please share the draft of the complaint. Now, you also have something which we call as a presumption under the NI Act, which is under section 139 of the NI Act. Now, what exactly is a presumption under the NI Act? Presumption is that there is a presumption under the law of NI Act that whenever a check is issued, it is issued towards a legally enforceable debt slash liability. Now, this presumption has to be rebutted by the accused during the course of trial or to the reply to the demand notice, that how the liability does not exist and how no case under section 138 is made up. This is how your complaint would look. You will have the full title wherein the full address of the complainant and the accused would be mentioned. Please go down. Then you have the complaint under 138 of the NI Act. I, the so and so, the complainant. Here, if it's a company, you will write the complainant company. If it's an individual, you will write an individual. You state on solemn affirmation, I'm a businessman by profession, and whatever was mentioned in our notice, we have replicated the same thing over here in the complaint. Only difference is now we are going to be annexing all the relevant documents. Like we will be annexing the declaration, we will be annexing the demand notice, the check, the dishonor memo, the demand notice, the dispatch proof of when it was dispatched to the accused. Then the proof of receipt, if it is sent by RPAT, you have the acknowledgement card. If it is sent by courier, you have the tracking report. If it is sent by speed post, then also you have the tracking report online. All these things are to be annexed. Please go down. I'll go down at the end. Now, 1 minute, 1 minute, 1 minute. Go up. Or yeah. Now, if you see over here, this is how your paragraph goes as you mention about the demand notice, then you annex the copy of the demand notice, copy of the dispatch receipt. Dates are something which are very, very important in a 138 case. Always remember 138 proceeding is a very technical proceeding and dates are very important in such a proceeding. So that is why you have to mention everything with the dates. Okay, so dispatch received was 16/8 so and so. Showing delivery, we have copy of the electronic receipt which was sent to the accused by professional couriers, showing that it was delivered on 17th of August. That also you annex. Okay. Then this line will come that a demand notice was duly served to the accused at her above address on which is her correct address. In case you send the notice and it comes back as addressee not found, or it comes as door lock, then you will write the line that it has been sent to her last known and correct address. And this is the only address which is known to us of the accused, and that is why we had sent the demand notice to that. I further submit that the accused did not reply to the demand notice, nor did she pay the amount covered by the aforesaid check within 15 days grace period. Oops. That a cause of action arose to file this complaint against the accused. I maintain my bank account. Now, always remember how the limitation, how the jurisdiction to file a case is taken under the NI Act. It is always taken as per where the complainant maintains his bank account. So, for example, here if you see that the complainant maintained his bank account at Vashi, so the case had to go to Belapur. It cannot be that he goes to Himachal or he goes to Manali and goes and deposits in a branch of IndusInd Bank at Manali and goes and files the case at Manali. No, it has to be filed where he maintains the bank account, where his bank account is situated. So he may deposit the check anywhere in India, but where the main account is in which branch, the limit jurisdiction to file the complaint is taken as per this. Earlier, we had 5 jurisdictions, then that was altered by a notification, by a judgment of Dashrath Roop Singh or by the Honorable Supreme Court, which said that where the accused resides, the complaint has to be filed where the accused reside, which created a massive chaos all over India. For 2 years, the cases were only getting transferred all over India, and it caused a grave prejudice to the complainant, because once a complainant also loses his money, then if the check gets dishonored and he has to go and file a case, for example, say I am in Vashi and the complainant maintains an account at Calcutta, I had to go and file a case at Calcutta. So this was then set aside by a notification by the central government, where the central government set aside the judgment of Dashrath Roop Singh and clearly clarified that no, the 138 cases will be only filed where the complainant maintains his bank account and not the accused. So now we have only one jurisdiction, one territorial jurisdiction, that is where the complainant maintains his bank account. At the end of the complaint, you will always write, aforesaid check dated so and so was dishonored on the same date. Demand notice was sent on so and so date. Accused to her last known and correct address being her residential address. Demand notice was served upon the accused on 17th of 8. Complaint is filed within the period of limitation after giving the 15 days grace period to make payment as required under law. Please go down. And this is how your prayer clause will go as. Now, here this is an error. One read with 141 will not come. 141 comes into play when there is a company involved. If there are directors you are prosecuting, then your 138 complaint will always be filed 138 read with 141. If in case it's only an individual, then it will only be 138. So this honorable court be pleased to issue process against the accused for commission of offences punishable under section so and so of NANI Act. Accused be dealt with and proceeded with in accordance with law. Directed to pay compensation to the complainant under section 357 subsection 3 of CRPC, any other order. Always remember, it's only under the NI Act and the DV Act that you can ask for compensation, not under the criminal law. Under the criminal law, you only get punishment, you don't get compensation. Compensation can be awarded, can be asked for when you file a case under the NI Act or a DV Act. Okay, this is how your complaint goes as. Now, coming back to the NI Act, coming down to the presumptions under 139, you have presumptions as to 139. Then you also have something which we call as material alteration. Now, what exactly would be material alteration? When there are alterations in the check, when there is any, alterations in the signature of the check, all these things are to be also considered during the course of trial. Once you file the complaint before the court, and then it is placed for verification of the complainant. A verification statement of the complainant is filed, and the original documents, including the check, the memo, the demand notice, the dispatch slip, the receipt, everything, all the original documents are to be verified from the court. It looks at the original, compares it to these photocopies which are being filed before the court, and then will give an order of process, or that is issuing summons under section 204 against the accused. Now, once the process is issued and served to the accused will come to the court and enter upon his appearance, and also file an application for bail. Why bail? Though these offences under section 138 are bailable offences, once the accused comes, he has to, on the first date, file wakalatnama and file an application for bail. Along with that, you will also file an application for cash bail, that you be released on cash bail, because the process of surety takes time, and in NI cases you are maximum time released on cash bail, which is you deposit a certain amount of cash and execute a bond, a cash bail bond, and you are released on bail. Once this is done, matter is placed for the recording of plea of the accused. Plea of the accused is actually recorded on the same day he is granted bail. Once that is done, the plea is basically sending the accused to the witness box, putting up the case to facts of the case to him, and asking him that whether you plead guilty or you plead not guilty. That's it. Of course, the accused will plead not guilty, and once he pleads not guilty, as soon as he pleads not guilty, the matter is placed for the affidavit of chief examination to be filed on behalf of the complainant. Now, what exactly is an affidavit of chief examination? Affidavit of chief examination is wherein the complainant enters the witness box, files an affidavit on under section 145 of the NI Act. He deposes about the facts of the case, proves the document. Now, what do you call by proof of document? Proving of documents is always under the chief examination. Now, what exactly do you mean by that? It means that when the complainant will go into the witness box, depose about the document. For example, say I'm saying about the declaration dated so and so. So, Atilika, can we just open the chief examination? We are talking about the declaration dated so and so. He will mention that the original declaration dated so and so is placed on record of this honorable court. It bears the signature of the accused. I can identify the same. The contents are true and correct. The same may kindly be taken on record of this honorable court, be marked as an exhibit, and be read in evidence. Go down. एक बस ऊपर 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 go up और ऊपर go up. Yeah. So now if you see this, I am placing the original declaration dated so and so issued by the accused and signed by the accused. I can identify the signature of the accused. Contents are true and correct. Same may be taken on record by this honorable court, marked as an exhibit, and be read in evidence. This is how a chief examination is to be. This is how you prove the document. How you prove the document? You identify the document. You identify the author of the document. You depose about the contents being true and correct, and then you urge the court to take it on record and mark it as exhibit. Mere marking of exhibiting, Geeta Marine's judgment of the Honorable Bombay High Court clearly says mere marking an exhibit of a document would not amount to proof of the documents. You have to prove the documents, and proving of documents, this is how you do by leading oral evidence. When you put the complainant into the witness box and he deposes about the document, leads oral evidence about the document, that is called as proving of documents. Now go down. Like here now we have produced the checks before the court. So that is how you will say I submit. Go down. Go down. Go down. एक मिनट ऊपर 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 ठीक है ये ठीक है ये ठीक है पेज नंबर 4 go down to page number 4 yeah okay I deposit the check then can you go down a little. The original check bearing number so and so, dated so and so, drawn and Indus Bank, Temple branch for an amount of rupees, bearing the signature of the accused is placed on record. I can identify the same. Contents are true and correct. Same may be taken on record by this honorable court, marked as an exhibit, and be read in evidence. Now, you also have something which we call as electronic evidence. Now, if you go down, you also have something which we call as an electronic evidence. What exactly is electronic? Emails, WhatsApp chats, here, your delivery reports taken from the internet. These are called as electronic documents. Now, there is a procedure of proving electronic documents under the Indian Evidence Act. Whenever you produce an electronic document, you also have to file a certificate under Section 65B of the Indian Evidence Act. A certificate under Section 65B basically is wherein the person who has taken out the printout of the electronic document deposes before the court that I have taken the printout of this document. The contents are true and correct. At the time when this printout was taken, the electronic device was under my control and without any human intervention. For this, you have the judgment, the three full bench judgment of the Honorable Supreme Court of P.V. Anwar versus Bashir. If you read that judgment, it beautifully explains Section 665B of the Indian Evidence Act. In fact, this now has been changed in the new laws which will come into force from 1st of July. Luckily for us, proving of electronic document was very difficult earlier. We had to produce the original source of the electronic record. For example, say if I'm saying that this is my phone and I have recorded a video or a WhatsApp chat through this phone, and I produce the printout or I produce the audio recording in a pen drive, I had to produce the phone also before the court because this was the primary evidence. But in the new law, which is not going to come on force from 1st of July, this factor has now been changed. The government has now made it very beautifully and made it very easy to prove electronic documents, wherein even if you copy the clipping in a pen drive and produce the pen drive before the court, the pen drive now becomes the primary evidence. So you don't need to produce your phones before the court. You don't need to go through that whole procedure of comparing and verifying it with the original. Even if it is after, even if it putting it in a pen drive, you take a printout and produce a printout, then that printout will be taken as a primary evidence. So now electronic evidence from 1st of July is going to become very easy to be proved. So, and always remember earlier, so this is for people who are practicing, who are going to have matters before 1st of July. You have trials which are going commenced, which are already commenced and going on from earlier. Lawyers like us who have to practice both the laws, they need to know both the laws. So always remember that if there is an electronic document, you need to produce a certificate under section 65B, because if you don't produce a certificate under section 65B of the Indian Evidence Act, your electronic document would not stand proof. And the proper procedure would be, you will have to produce the primary evidence. Say if I want to execute some WhatsApp chats, I produce a printout, I will have to produce the phone in which the WhatsApp chats are. The court will compare and verify and then mark the printouts as an exhibit. Until unless you don't want, you can submit the phone also in the court. If you don't want to submit it in the court, you need it for your day-to-day usage, you can get it compared and verified. So always remember this. Okay, go down, go down. This is how you will prove all the documents. Once this is done, at the end you would say that the case under section 135 is made out, 138 is made out against the accused and needs to be convicted and awarded the maximum punishment with further directions to pay maximum compensation as provided under the law. Once the chief examination is filed, the documents are exhibited by the honorable court. Then the matter is placed for cross-examination by the accused. The accused law advocate would conduct the cross-examination of the complainant, and then it is kept for any other witnesses which the complainant wants to examine. If they want to examine any other witness, those witnesses are examined. Same way the chief examination is conducted, the cross examination are conducted, and the evidence of the prosecution is then closed by filing a process if they don't want to lead any further evidence, that the complainant does not wish to lead any further evidence, and therefore the evidence may kindly be taken as closed. Once the prosecution, that is the complainant, closes the evidence, the matter is placed for statement of accused under section 313 of CRPC. The accused is put into the witness box. Circumstances are put to him, whether he says true or false. After the statement under 313 is recorded, the matter, if the defense wants to lead any defense witnesses, the defense witnesses are led. If not, then the matter is kept for final arguments and judgment. Now, what is the defense do you take in a 138 Act? Always remember, 138 is a very technical act. So the first defense you would have to be take is whether you would need to see is whether the complaint is filed within limitation or it is for not filed within limitation. Second thing which you need to notice is whether the check was issued towards any legally enforceable debt or liability, whether any liability existed on the date the check was issued or not. Second, third, you need to see whether there are any material alterations, any documents, so that it needs to be sent for forensic examination. Fourth, you need to see, which is a very common defense which is taken in 138, is that the check is issued towards a security. That means whether the check was given only for security purposes and not for deposit purposes. Always remember this. Okay, so all these things are to be noted. Am I clear? Now, once this is done, these are the defenses which you take in a 138. So you have something which we call as instruments which get dishonored. Once dishonored, offense under section 138 is to be it is invoked. Once the bank memo is received, within 30 days you have to file the you have to send the demand notice. Once the demand notice is sent, within 15 days, if he doesn't repay back the money, cause of action arises from the 16th day, and within 30 days you have to go and file a complaint before the court. And the court fees, I don't know about the other states, but for Maharashtra, under the NI Act, the court fees is 2% of the check amount, and 1.5 lakhs is the maximum court fees. That means you may have a check of say 1 CR, but the maximum court fees you will have to pay on the check would be 1,50,000, not more than that. So 2% of the check amount, that means, for example, a simple calculation would be 200 on every 10,000, 2,000 on every 1 lakh. That means for every 10,000, you have to pay 200 rupees court fee. For every 1 lakh, you have to pay 2000 rupees court fee. That's the easiest way to calculate the court fees. So if you have a say a check of 25,000, you will have to calculate as a round figure. You will have to calculate the court fees as a round figure for 30,000. So it will come down to 200, 200, 200, 600. You will calculate the court fees as for 30,000. Similar way, if your check is say of 3 lakhs, your court fees will be 2,000, 2,000, 2,000. That goes to 6,000. That's how you calculate the court fees in a NI. Your check may be for say 2.5 lakhs, 2 lakh 50,000. Then you will calculate your court fees is 2 lakhs, for 2 lakhs 4,000, and for 50,000 for every 10,000 to 200. That's how you will calculate your court fees. So this sums up your today's lecture on the NI Act. Over to you, Swatileka.
Thank you, ma'am. So, ma'am, I would like to ask you some questions as usual, which our students
Sure,
have
sure.
asked during our sessions. The first question is whether negotiable instruments can be taken as a recourse into void contracts.
No. In fact, if you see there is a specific particular judgment of the apex court similarly on that point, that where there are void contracts. For example, say if I go and I tell a person comes up and tells it to me that I can get an admission for your child in a medical college on, and you need to pay me a certain amount, and I pay an amount to that person. Okay. And that person fails to procure the seat for my child, and he issues me a check and I go and deposit that check. This is an illegal contract. Okay, this is a void contract because this is legally not maintainable. It's something which is illegal as per law. So I cannot take recourse to NI Act because negotiable instruments act cannot be taken recourse for void contracts. The law is very clear.
Got it, ma'am. Secondly, can a check be redeposited like multiple times till its
Yes, it
validity?
can be redeposited multiple times within the limitation period, that is the 3 months. But always remember, for example, say if if you have deposited it once, okay, and it has already been dishonored. But if you don't send a demand notice, and then you can redeposit it, and your have gotten over. So whether if the 3 months are not expiring, you can redeposit it so that you get the limitation of 30 days again, and then you can send the notice. But if you've already sent a demand notice, then you cannot redeposit it again. But yes, it can be redeposited multiple times so that your limitation increases. But the demand notice has to be sent as per the latest dishonor. Once a demand notice is sent, then it cannot be redeposited.
Got it, ma'am. So, thank you, Beeta ma'am, for the very insightful session today. I hope everybody has enjoyed this webinar. We will meet again next week on the same time, Sunday, 8:30 a.m., and continue this series with more practically useful topics and information. But also ensure that you are commenting and asking us questions and queries at the end of the sessions. Till then, please take care of yourself and have a great day to you too, ma'am. Thank you so much, everybody.
Thank you. See you next Sunday. Bye.